Universitas Hasanuddin. Yeah, I'm pretty pleased to be invited once again after a long silence, a long hiatus. Yeah, probably. I think the last lecture I had was last year, which I had presented something on legal methodology. That is for your postgraduate students. After which I had a long silence, I think due to the urgency of COVID-19 situation. All of us are pretty much into taking care of ourselves. And I hope that this particular subject on liability for environmental damage will actually open up a little bit of perspective on how we can ensure our environment is being prevented from um, being harmed by activities taken by another state. Yeah. Let me just give you a situation, a simple situation before I begin my presentation at the a different level altogether. I'm giving you something which you can relate to. Think of a situation whereby your home, yeah, you're living in your house, you have a neighbor. Now, this neighbor of yours decided to carry out an activity. For example, you know, laying down a foundation for a swimming pool, for example, yeah? And then for one reason or another, when he was actually putting in water into the swimming pool's foundation cracked and the water seeps into your, gallons of water seeps into your area, your house. And obviously, you have suffered some kind of harm or damage. Yeah, that's a simple scenario. Now, after which, once you have suffered some kind of harm or damage to your property or perhaps to yourself, the question is, how are you going to take an action against the neighbor? So that's a simple scenario that you can think of in terms of seeking for compensation, seeking for liability from your neighbor. I'm not sure whether in Indonesian law you have this concept of law of tort. Bu Rafika, duty of care. Do you have that? I'm not sure about Indonesian law, but do you study law of negligence?
Uh, I'm not familiar with
Law of torts?
private.
Yeah,
The,
because
that
private
that's
law.
yeah, that private law. I don't
Yeah,
really remember,
right.
but
Okay.
I think they have one. Yeah, I think we have one.
Okay, right. Now, because under our laws, because we somehow adopt laws from the United Kingdom, because remember,
Mm.
Malaysia was once, being colonized by the English. So we adopt certain kind of laws,
Mhm.
specific kind of laws, and one of the laws would be on law of negligence. So that is pretty close to what we are trying to ascertain whether or not, in that particular scenario that I gave you, whether your neighbor is liable or not for any damages or harm that has occurred in your in your backyard, in your home. This notion of duty of care, this notion of law of negligence, whether or not these notions apply in order for you to make claims against your neighbor. So that's a simple scenario. Now, bear that in mind. You think about this, and I want each and every one of you to write down, if you were to take an action against the neighbor, what would be the list that you're going to write? Number one, what are you going to claim for? Okay. So I want each and every one of you to list down and figure out, yeah, I think during this 2-hour presentation, you can do that. List out what are the things, what are the possible things, what are the possible damages and harm that you wish to claim from your neighbor due to the due to the seeping of gallons of water into your home. So think, what would be the effect of that? Right? The possibilities, yeah? Okay. Now let's carry on with my presentation. Now, even before we go into the intricacies of international law, when it comes to asking or seeking this reparation or claims from that particular neighbor of yours. Yeah, look at it from the international context. You must be able to figure out the facts of the case. So the facts of the case in the one that I given you earlier would be a transmission of water from one place to another. Now we have that at the international level. Okay, we have all the situations and scenarios, incidences at the international level. One of which would be the aerial herbicide spraying Ecuador versus Colombia. So this was actually done in 2008. Basically, it's very simple. It's similar to the situation that I've given you just now. It's basically a transfer of something, yeah, an effect of something caused by a particular activity that was taken place in another country. So this is basically a kind of harm or damage that was brought upon by that particular activity into another country. So that is from the international aspect. So in this case of aerial herbicide spraying, Ecuador had actually filed an application of some sort of a claim against Colombia because they found that Colombia was spraying this toxic herbicides at locations near, at, and across its border with Ecuador. So basically, Ecuador is saying, hey, look, because of the fact that you're spraying all this toxic sprays into, fumes into into your supposedly area, it has somehow affect the environment and causing serious damage to people, to crops, to animals, and to the environment on the Ecuadorian side of the frontier. So in other words, the activity that was taken in Colombia has affected those people and the environment in Ecuador. So basically, Ecuador is asking for some kind of a compensation. Because of that, we have somehow suffered, somehow suffered, and we are being affected by that spraying of poison. Yeah, herbicide is basically it's poison. Yeah. So at the end of it all, they went to the jurisdiction, to the courts, on the basis of Ecuador's jurisdiction. And obviously, Ecuador invoked some kind of a rule, yeah, based on the Pact of Bogota in 1948, whereby both states were party thereof. So I want you to keep in mind, these are some of the situations, one of the situations by which transboundary harm may occur. Transferring of harm, transferring of chemicals of, effects of certain activity into another state. So the next illustration that I can give you would be the Smelter arbitration in 1941. This is some of the, one of the most infamous, very popular case. This is one of those highlighted case in international law. And I'm sure that many of you have come across this when you talk about transboundary effects of activities in one country that has been transferred into another country, and that country, be that as it may, is United States. And this occurred in Washington, yeah, in 1906, caused by the fumes from sulfur dioxide from the smelter, which had resulted in the damage of the state of Washington. So here again, United States was quite adamant in the sense that they have invoked a suit against Canada and asking them to stop. So an injunction is to stop the operations of the smelter so that no further air pollution can actually be transcended beyond borders of Canada. So this would be another case. And the other case which I need you to look into would be the case between Argentina versus Uruguay. So when it comes to this case again, it talks about the activities taken by Uruguay when Uruguay had come up with the construction or the building of two pulp mills. And this is basically on the River Uruguay, where they are basically sharing, yeah, yeah, the river between Argentina and Uruguay. Now, obviously, there'll be some contamination of water, and it has impaired the quality of water in Argentina. So if we were to see all these three cases, basically the same trend or the same message will come across, whereby one activity of one state, yeah, has caused some kind of environmental harm to the other state. So that is a simple way of looking um, um, at invoking proceedings against one state to another when it comes to environmental damage. So you need to know what causes it, what will be the effect of that activity, yeah, and at the end of the day, if you wish to come up with some kind of a suit against the other state, you would need to understand or need to define, you know, what is considered as environmental damage or harm. What is it? Yeah, when you say environmental damage or harm, what is it? What does it constitute? Yeah, so you need to define that. So bear that in mind as well. So these are the cases which I would like to highlight when it comes to seeking the background to seeking, yeah, environmental liability when there is harm or damages suffered by the affected state. Now, this one, I think we all know, we've been sharing this problem for the past, from 1998, even prior to that would be about 20 odd years. Yeah. And luckily enough for us, we have somehow avoided this issue, I think, for the past year or so. And we were concentrating more on overcoming the challenges posed by COVID-19. So if you were to look back in 2020 and even in the first half of 2021, there is no issue at all on this transboundary haze that can impose environmental harm to the population of those countries which are affected. But looking back, yeah, the implications of transboundary haze pollution. The main three actors when you talk about transboundary haze would be Malaysia, Indonesia, and Singapore. And all these three states are affected by the impacts of transboundary haze. There's no doubt about that. The question is, when you talk about from the affected states, let's say, for example, let's twist the situation around. The alleged offender or the alleged violator is Malaysia. Yeah, because of certain palm oil concessions, we have burned them, and that has caused transboundary haze that went into your country, and that has caused a lot of discomfort on the population of Indonesia. And again, discomfort on the population and also the harm or damage done to environmental resources in your country. And that would include the environmental habitat, the flora and fauna, the quality of water, and the quality of air, yeah, to say the least. So here again, you would have to ask yourself, if you are lawyers, if you are the prosecutors, international prosecutors for Indonesia, you wish to take a legal suit, yeah, against Malaysia for any kind of liability, for all the environmental harm environmental harm and people suffering and all that, yeah. The question is, under what law can you invoke in order to place some kind of liability on Malaysia? And that could be vice versa. So obviously, when you talk about states, you would have to certainly impose or apply the rules of international law or international customary law. And the case that when you speak about this liability issue, state liability, because you're imposing some kind of a liability on a nation, on Malaysia. So you would have to invoke this topic under international law of state liability. Now, state liability, as you know, there would be, I will talk about it further, yeah, you would have to apply certain factors in order for you to successfully invoke the liability of a state in order to be compensated for any environmental harm. So in that aspect, again, one is you talk about state liability, and the next step basically is asking for remedies, yeah, in order to restore or to compensate for cleanup processes and all that. But on the other hand, when you talk about state liability, it's not only confined to getting compensation or monies. Yeah, you have to embed within it certain approaches, which is known as um, these terms. Yeah, you keep that in mind as well. The first one would be precautionary approach. The second one is preventive measures. And the third one would be due diligence processes. Now, you have to remind yourself that these three terms are closely connected to this idea of um, seeking liability, telling that country, you've done something wrong. You need to compensate for it. You need to remedy the effect in my state. And those three terms must come to mind. Yeah. Again, I repeat, due diligence, preventive measures, and precautionary measures. So those three things must be within your discussion. Okay. Next would be, why do we need to impose liability on that country, the violator? Now, basically for all these reasons, yeah, to provide some kind of an incentive for compliance of a certain rule or law, yeah. Second one would be to actually tell them, to impose penalty on them, saying, hey, look, you've done something wrong. We need to provide some sanction for that particular violation that you've committed. So that is considered as a sanction for wrongdoing. The other one would be, obviously, when something which has already been damaged or harmed, you are actually imposing some kind of corrective measures for you to restore, to bring that particular harm, to restore it, yeah, in whatever way you can, and put it back into a status quo position. Okay, just the status quo position would be a situation by which that particular thing or a particular place is um, remedied, so that it goes back into the position where the harm had occurred in the first place. Now, next one is, obviously, when you talk about this liability, the purpose of it, you would also have to look into the other social and environmental costs of pollution processes. That means you talk about the cleanup processes, monitoring processes, and you would have to look into, for example, flora and fauna. You would have to figure out what are the costs of ensuring that these flora or fauna are protected from further environmental harm if that were to occur in the future. So all of those things you would have to figure out when you're asking for liability, what's the purpose of this? But more so in some countries, yeah, this sanction for wrongdoing, if you talk about liability, state liability, it is not actually, basically there's a reluctance, there is an hesitation on imposing liability on states. Now, this has a lot to do with political nature or relationship between countries. And I think we can relate that because we are a part of ASEAN. And if we were to look into our own country, a country's position on haze pollution, yeah, you'll be able to see or be able to read, and it can be suggested that it's also to do with our own interrelationship with one country to another. What's the culture between Indonesia and Malaysia and any other countries in ASEAN? Yeah, basically we are more into cooperating with one another, not so into blaming one another and asking for compensation. That has not been done in ASEAN before, especially so when you talk about state liability for transboundary harm. And I think that particular case of transboundary pollution has occurred in Malaysia, Indonesia, and Singapore for more than 20 years that have actually highlighted the fact that we're more into seeking cooperation. But things may change in the future. Let's just move on to the next slide. So basically, when you're looking back at this issue of liability, um, you wish to impose some kind of fault on that particular state, that violated the that carried out the activity, and also whether or not it extends into civil liability. In other words, whether you as a person was affected by that particular activity that caused harm to you as a third party, whether you're allowed to do that under international law. So there are two situations in which you can impose liability on. Firstly, on the state itself, countries, nations, or international organizations. And the second one would be on civil liability, meaning whether you as an individual can take an action against that particular state. Yeah. So when you talk about liability again, you would have to know that it is only for illegal acts or for adverse consequences of lawful activities. Now, I will highlight to you certain words, but of course, I would like all of you, after this lecture, go into the intricacies or the definitions of certain words. Yeah, the first one would be under international law. What is meant by illegal acts? What is meant by criminal acts? What do you mean by adverse consequences? What do you mean by lawful activities? So those kind of terminologies, you'll be able to find them in various international conventions or even in cases. So throughout this presentation, I will refer to you to various international treaties, agreements. Yeah, I will only highlight them. Obviously, under liability, there are many, many examples, of which those that I'm going to present to you, they're not exhaustive. But when you talk about liability, you would always have to refer to the International Law Commission on articles or draft articles on state responsibility. This one you can actually look into, you can Google it up, yeah? You'll be able to find that on International Law's website, yeah, on LexisNexis and so forth. So please, when you speak about liability issues, refer them to draft articles on state responsibility under ILC. Now, when I say draft articles, okay, from the word draft in itself, it is only a draft. It has not been agreed by or accepted by all countries. Yeah, so it's only a draft. It is only a guide. So it's nothing of a treaty in terms of its enforcement, or even an international agreement. It's something that they were looking into on how to impose state responsibility on activities taken by countries, nations. Okay, so go back to the situation that I've posed to you earlier on. I asked you to list down what would be the likelihood or what would be the possible items that you wish to be compensated for. What are the things that you wish to be remedied? What are the claims? Yeah, so you might have already conjured up, some items. You need to determine when it comes to environmental damage, liability for environmental damage. You need to define what is environment, and this is an ongoing discussion of what is actually is environmental damage, or the word environment in itself. So if you were to see even the ASEAN agreements that we have on the environment, or even in Transboundary Haze Pollution Agreement in 2002, the environment's definition differs. It would depend on that particular state, on that particular region, on that particular interest of those states. Yeah, in a region, or as a bilateral cooperation amongst one another, They would have different kinds of definition of environment, and they would suit this definition of environment into their own interests. But generally, if you were to look into your own act, yeah, definitely there will be a definition on environment. And they would include, obviously, all these terms: fauna, flora, soil, water, climatic factors. And some now, they even include climate change as one of the environment, meaning of environment. And it would also include those terms such as material assets, um, all these archaeological sites and heritage. If you consider a particular building as a heritage site, anything that would happen to it, an erosion of paint and all that, that can be considered as under the definition of environment. So any damage were to occur on that particular building, if you regard that as an historical building site, um, you may claim for that. Yeah, whatever deterioration on that building, you may claim for that. Obviously, it would go into environmental landscape and amenity and interrelationship between the above factors. Now, when you talk about environment, it can mean anything. Okay, um, I would like to ask you, okay, any one of you that would, that what would be the definition of environment to you? Okay, is there anyone that can share with me what do you think apart from this, and how does it, relate from one aspect to another? Can anyone share with me? Have any idea? There's no wrong or right here. Just your opinion on this. Anyone? What would you what would you how would you define environment apart from this? In your laws, how would you define it? Tak apa, nanti I'll ask them towards the end, Bu Rafiqah, yeah?
Okay.
They might be thinking right now. Okay. So let's just move on to the next slide, yeah? Okay. This is the one that I wish to share with you. When you talk about the environment, it can be anything under the sun. Even the space can be considered as our environment, right up to that, to a level. Yeah. So if you were to look at this interdependent view of the environment, you'll be able to see that all these aspects are interconnected with one another. We can't help that. We are all interdependent. Each one of this will be interdependent on one another. Let's say, for example, if the soil erosion occurs, if the land degrades, if there is some deforestation going on in your area, in your country, obviously it would affect water quality. Yeah, obviously the water quality will decrease. It will affect the population because once water quality is affected and there's soil erosion, there's no space for you to live, there'll be a transmigration. Yeah, where you move into, and the human settlement areas will be affected. Again, you'll be talking about the protection of ecosystems. You're talking about the protection of natural resources. You're talking about how do you protect endangered species? Because the moment you move, transmigration, there'll be lesser land, and all these species will be affected. Yeah, all animals and flora will be affected. So basically, all of this on the interdependent view of the environment. Remember, at the end of it all, when we talk about the environment, everything has a triggering effect on one another. It's a domino effect, right? So if you were to look into the picture on the right, again, it talks about that. It talks about how everything is related to one another. When you don't protect all of this, one of these items will, or more of the items will fail, will suffer. Okay, so this is what I want you to look into. When you talk about the environment, you remember everything is interlinked. You cannot disregard one from the other. You cannot separate between water quality and, for example, population. You can't. Or air quality with population, or climate change. You cannot. So however small the impact is, definitely one of each or more than one of these items will be affected. Bear this in mind. It's utterly important that you understand this. So in other words, you can't say that whatever that I'm doing, if I'm throwing plastics into the sea, it won't affect anyone. It's an individual act. It won't affect anyone. That's wrong. Whatever that we do now, or we have not done anything by omission, obviously it will affect one of the other. So be very careful when it comes to this. So everything we do is actually, our responsibility. That's what I'm saying. So let's go back into liability. Yeah. Um, Basically, in international statements, international agreements or treaties, you will find this word liability appearing in many, many agreements and treaties in all those provisions within it. You can find that under Principle 22 of Stockholm Declaration. I want you to look that on your own. I'm not going to give you a detailed one, because this, you see, that the whole issue on liability is immense. I'm just going to highlight you and perhaps put you in a position whereby you can do a little bit more research on your own. Yeah. So you can look into this liability, this term liability that appears in many of the international agreements. Principle 22 of Stockholm Declaration, for example, that talks about the state liability, that talks about you should not cause any kind of injury, any kind of serious effects to another country if you're carrying out this kind of activity in your own country. It appears in under Principle 22. Of course, under Principle 13 of Rio Declaration and 1982 World Charter for Nation. Now, it was suggested that if you were to look into Principle 13 of Rio Declaration, and I think in most of the cases, in most of the international treaties that I've looked into, there is some kind of a degree of hesitance, yeah, to pursue this topic on liability, because no one wants to be liable for anything these days, yeah. So especially, you have to know about this politics between the North and the South, yeah, states, North and the South. The North states are considered as first world countries. For example, the US. The South countries are like us, yeah, the developing countries. So there's always been this struggle between these two, yeah, and remember, the US is a very strong force, yeah, and they somehow, I think the North somehow would not like to be put in a place where they are to be blamed for their activities, and they would not want to pay for anything, because this will cause a lot of upheaval in their monetary institution, yeah, where they need to pay, quite a bit of a sum, and a lot of technicalities that go into assessing those type of damages as well when it comes to environmental harm. But when you talk about liability, state liability in itself, not, well, I can say all countries to a certain extent have portrayed their reluctance in agreeing to some kind of a state liability. And you'll see that in cases, yeah, whereby at first, they bring it, they bring this issue of claim to ICJ. They bring this issue of environmental harm or damage to their own countries, yeah. But yet, at the end of it all, they kind of settle it outside. Yeah, they kind of settle it outside, and they do this on the basis of cooperation and just trying to move away from this issue of liability. Yeah, they do not want to be called, hey, I think most, if not all, countries are like that. So you keep that in mind. We have a fantastic theme on state liability, and yet there is this some kind of um, push, yeah, for this issue to be, to be stamped as an international law. Okay, now, obviously, there are certain things that, or certain factors that you need to consider when you talk about state or civil liability. Like I've mentioned before, first and foremost, you would need to define environmental damage. What is environment in the first place? What is considered as environmental damage? Now, in all of this, you'll be able to see in cases, yeah? Those cases that I've mentioned to you earlier, you'll be able to find that this definition, this coming up with this, what's a definitive translation of environmental damage? What constitutes this? The other one is how to establish duty of care on that particular state, to say that, hey, state A, you have committed a breach of duty of care, you did not look into the welfare of the other state when you were trying to carry out the activities in your country, and that you would need to determine on three kind of basis. The first one is absolute basis. Absolute means, that's it, you are at fault, you would have no defenses given to you, and there will be no you will not be denied from committing that activity that have caused environmental damage to the other state. The second one is strict liability. Strict liability is, yes, you have caused it, but what are your defenses? Okay, what are your defenses? The third one is fault basis. This one is the simplest form of breach of duty of care. Meaning, you've done it, you have shown that you've, taken some kind of preventive measure, and, because of certain things that you've missed, you're given this kind of a leeway, flexibility. So that in that bit, you would have to establish under one of those bases, absolute, strict, or fault. The next one would be, this one is another problem as well. Who would you bring that claim against? Look back at the situation which I gave you earlier, your neighbor and yourself, right? Now, let's say your neighbor instructs a contractor to build that swimming pool. Okay, now you would need to identify who had breached that duty of care. Is it your neighbor, Mr. B, or is it the contractor who's actually building the swimming pool? So that you would need to determine. Next is who should bring the claim. Obviously, in your case, for example, the first person that can bring the claim is obviously you yourself, you being the state, and let's say, for example, there is someone, there is a police officer, no, not a police officer, there is a postman who comes into your home delivering your letters. And at that moment in time, when the water, gushed into your surroundings, into your home, the postman who was bringing your letters was swept away, and he's swept away by the water, and he fell into a drain and broke his legs, for example. Can he bring a claim apart from you? So in that particular situation, you would need to determine who can bring the claim against your neighbor or the contractor. Next one would be the jurisdiction and proper forum which claims may be brought. That means you must have this access to justice. Jurisdiction, okay, if you were to look into the case of the Gapci Kovo case between Hungary, what's the other one? Hungary and what's the other state? Can't remember the other state. Now, again, in most of the cases, usually The jurisdiction and proper forum will be the country that seeks to claim redress from. In the Trail Smelter case, it was under a tribunal. In other cases, it could, like I said, in Gapchikovo, it went into that jurisdiction of the country that's seeking remedies from. Okay, so you need to determine which proper forum. Is it the ICJ? Is it your home country's courts, high courts, lower courts? Or even it could be a international tribunal, international tribunal, which is formed in an agreement or in a treaty agreed by those countries. Okay, so if you were to look at Trail Smelter case, it is actually under an international tribunal formed between these countries under a certain agreement. So we need to figure that one out, access to justice. Next one would be you have to determine what kind of available remedies that you can get. And that is the exercise that I gave you earlier. What would be those remedies that you wish to get from your neighbors? For the postman, for example, you know, he broke his legs, right? He may not work for the next 6 months because of his broken leg, for example. Okay, what would be the usual remedy or the usual compensation, usual what do you call this? Usual items that you would need to, that you wish to get from the other party. Obviously, in the postman's case, hospitalization bills, for example, medical bills, loss of opportunity, loss of job, for example, and he was asked to stop because he couldn't work for the next 6 months. So the post office says, hey, look, because of that, you know, you are out of a job, things like that, right? Or rehabilitation remedy, for example. So I'm giving you in that situation, yeah? So I want you to think, if let's say, in our situation, Malaysia and Indonesia, for transboundary haze pollution claims, what would be the available remedies that can be given to the public? Okay, or for the environmental harm done to that particular country. Next one is, I would like you to look into whether or not defenses are available, defenses are provided to the violators, to the countries who have violated their international responsibility, whether that can be afforded to them. Defenses meaning, you know, whether it is purely on, they didn't know anything about it, right? No knowledge of it. For example, let's say that, let's go back to your neighbor and yourselves dispute. Remember, there's a contractor there building your swimming pool, right? And you're in the house and you just leave everything to your contractor and say, hey, Mr. Contractor, I just leave it to you. You know how to build a swimming pool. You know, I'm just going to go on with my chores. Just carry on with your work. So basically, you are giving that responsibility to the contractor. The question is whether that can be considered as a defense by saying, hey, look, I have no knowledge of what's happening. You know, the contractor is the one who's doing all the work. I have no knowledge. I've already told him, you know, you can do whatever you like. You are the contractor anyway. You know what to do. The question is whether I am part of that as the owner of the house, whether that can be a defense. Okay, so something to think about. Next one is burden of proof. This is rather difficult. If you were to look into the case between Indonesia and Malaysia and Singapore on transboundary haze pollution, there's always this question on how do you ascertain that the state, for example, the state has failed to take any preventive measure in order to avoid transboundary haze pollution from happening. Now, I think if you can recall during, let me see, the big one was in 1998, in 2014, 2015. Let's go back to 1998. That was like, I think when you guys were not born yet, most of you, yeah? Now, what happened then was this. There are many concessions, palm oil concessions, companies, yeah, that have carried out so-called open burning, okay? And this open burning was alleged to have been committed by big companies, so they said. But there are also some uh, um, situations by which small farmers themselves, or even some illegal burning, yeah, and also some environmental, environmental um, kind of no one actually burns, but it's because of hot weather, natural causes, yeah, natural causes due to the heat, hot sun, yeah, that has triggered, for example, peat swarms. And you, as you know, peat swarms, they can actually light up, yeah, fires because of the chemical of the soil within it. So if there's too much heat, it will trigger fire. It will strike a fire underneath the soil, and it will trigger fire if it's in a very hot condition. So again, how are you going to pinpoint in those circumstances that the cause of transboundary haze pollution is due to the activity taken by the big companies? So the big companies can say, hey, look, we didn't burn on that day. We didn't burn on that day. It's just that, at the border of our concession land, there is some illegal fire or caused by cigarette butt, cigarette, who smokes right now, cigarette butt, where someone just flick it and, it causes fire. So how is another state going to prove that particular fire that caused transboundary haze pollution came from that company? So it's very difficult. It's very difficult because you need to have um, a map, an area of map, yeah, to see where does the concession land is, yeah, and then you would have to see at that moment in time satellite images during that particular time. Even that is not actually a foolproof. So that causes a problem. Basically, how to ensure that that particular activity or that particular harm was caused by that state. All right, so that's a problem. But you can look into all the other cases. You look at Trill Smelter case. If it's even if it's a clear cut kind of a case, you must be able to ascertain, this burden of proof. How do you prove it, right? Look at the maps, look at the satellite images, look at the testimony of the companies, testimony of people surrounding the concession. You've got to do a lot of investigation. And finally, let's say, okay, you go to the courts and you get some kind of judgment. Who's going to enforce that judgment? Is there an international body that will enforce the judgment? Let's say, for example, Thailand has successfully claimed against Myanmar or Cambodia for pollution of water. Okay, they have established that Cambodia has somehow carried out some kind of an activity that causes the water quality in Thailand to decrease, to decrease, yeah, in terms of quality. Now, after which, okay, the court says you are supposed to restore this using this method. You have to pay Thailand, up to a tune of so many million or billion bahts and all that, Thai baht and all that. And the question is, who is to enforce this liability, right? If that jurisdiction or the case is tried in Thailand, who is going to enforce the judgment on the state of Cambodia or any state for that matter, right? So sometimes you may find that your cases may be tried and successful, but problem is who is to enforce it. So that's another area that you need to look into, another concern that you need to look into. Okay, so when you talk about state liability, again, under the Article 1 of ILC, International Law Commission, which is a draft on state responsibility, it clearly states that The states will be held liable under international law rules of state responsibility for internationally wrongful acts of a state. So when you talk about a state, it also includes persons and organizations. And once that is proved, then you can impose this international responsibility of that state, and they can be tried and they may be liable. And in that case, kindly take a look at Articles 30 and 31, whereby if that particular state is very simple, if that particular state are held to be liable, and obviously some kind of reparation or damages to be paid to, or costs, of restoration, etc., basically under remedies to be paid to the affected state. So this kind of statement was actually affirmed in cases 1928 Shoza factory case, and then case concerning Gapchikovo and Nagimeros project. And also in this case of Gapchikovo and Nagimeros project, which affected Hungary and Germany, they were talking about this issue of significant harm, okay, or significant harm or damage done to a state. What do you mean by it? So in that case, they were saying that, the peril, the immediate peril must be imminent. It must be obvious for everyone to see. It cannot just be something that, oh, I think in the future it will affect Hungary, for example. So that doesn't gel. So you need to prove that the peril is grave and imminent, that can cause environmental effects or harm to that particular state. So please read these two cases where you can see that if the state, again, does anything which is in contravention with international responsibility, they will have to pay for it. Basically, that's it. Yeah. And it's also affirmed in Principle 12 of the 1978 UNEP draft principles. You can take a look at this, the legal principles in WCED and the IDI related to transboundary atmospheric pollution. Okay. So this is basically what state liability is all about. Now, when you talk about the state liability, you would need to know what kind of an act is considered as internationally wrongful act. So under this International Law Commission, I'm also very certain that while you're pursuing your public international law course, you'll be able to figure out what kind of act is considered as an internationally wrongful act. And I'm sure you'll be able to see in various cases. Yeah. So basically, I'm just highlighting to you under the International Law Commission draft on state responsibility under Article 2, it will consist two kinds of conduct. The first one is an active act, yeah, that you're actually doing something which is illegal, yeah, that would constitute a breach of an international obligation, or omission. Omission is something which you just sit back and you just look at it and you just say, hey, I have nothing to do with this, or just let it flow. So there are two ways of doing it. Either it's an active act or a passive act, which is an omission. You refuse to do something about it. So that they will determine whether or not that particular state has done something wrong. And this has a lot to do with the question of, remember I asked the three things, due diligence is one of them. So whether or not that state has carried out due diligence processes in order to make sure that everything has been done in order to prevent environmental damage to happen in that other state, in that neighboring state. So that would be the issue. And that would be the area of concern where the international courts will look at. Have you done everything in your power to prevent that? That's another issue. Okay, let's move on to, like I've mentioned earlier, not only when you go to the courts or tribunals to ask for compensation or reparation on the environmental damage which has already done, yeah, You would also look into what will the state do if the state intends to carry out or continue to carry out that particular activity. What would be in the ambit of discussion? Obviously, like I mentioned earlier, prevention mechanisms or measures will need to be considered, and also this issue of precautionary measure. If let's say that the country, tends to think that some other harm may occur, so before that thing ever happens, precautionary measures must be considered, right? Okay, so basically, if you were to look at the cases, yeah, that they have tried on this issue of state liability, at the end of the day, the judges will actually judge on its own facts, yeah, individual facts of that particular case. So, in a nutshell, these are the items that you need to consider. Okay, right. So again, I'm just giving you an extra definition on environmental damage. So what constitutes environmental damage? If you were to see in various treaties and state practices, it would mean different things. But more or less, it will actually, encapsulate this vision whereby, again, we always talk about fauna, flora, soil, water, and climatic factors, and all those things that I've mentioned to you earlier will be embedded within the the interpretation or the definition of the environment. And so whatever activities that causes harm or damage within that ambit, within that ball, that global ball just now, is considered as environmental damage. So you can take a look at the 1993 Lugano Convention. You can also take a look at the 2010 Nagoya KL Supplementary Liability Protocol to the Biosafety Protocol. So this one gives some kind of a broader approach as to the meaning of environmental damage. And the treaty definition can also be found in CRAMRA. This has a lot to do with the Antarctics, yeah? Antarctica, whereby, certain scientific experiments are going on in Antarctica, by various countries. So what is known as environmental damage, you can actually find it in that particular international agreement, yeah? At the same time, look into cases like Lanu arbitration, nuclear test case between Japan, there's Japan, Australia, New Zealand, and UK and the US, yeah? And also a case concerning certain phosphate lands in Nauru, Article 139 of UN Convention Law of the Sea. So I'm giving you some of this, so perhaps you like to look into after this lecture, yeah, or during your studies, yeah, you can actually read into this. And at the same time, you would have to consider also what level of environmental damage can actually give rise to liability. Now, there are two cases here, which are star cases when it comes to this question of what kind of environmental damage, how severe is it that you can actually bring that claim against that particular country? What kind of damage? How serious is it? How adverse is it? You sometimes, when you talk about certain injuries, yeah, in environmental damage scenario, in two cases that have affirmed this presupposition, whereby it says not all damage can create a legal cause of action. Not all, yeah. So when you talk about nuclear test case, when you talk about the Trail Smelter case, there must be some kind of an adverse, very, very bad, very serious environmental damage. It must be very significant. It must be very substantial that, you need to bring this to be tried in courts, or to be asking for reparation, to be asking for remedies. So if you were to see in the International Law Commission draft on state responsibility, you'll be able to read, and this term, significant transboundary harm, yeah, and that brings about significant change in the environment, you'll be able to see it in various treaties. Maybe not in that form too much, but you'll be able to find these words, significant, transboundary harm, and significant change in many of the treaties. So again, um, you must remember when you bring this claim against another country, yeah, you must understand that not every single damage you can get some remedy. Now let's go back to, I don't know whether all of you have come up with your own list in regards to the situation that I've given you earlier between your neighbor and yourself. Yeah. So look back at that list, and if you were to impose or apply this concept of significant harm or significant change to the environment in your own home, tick which one you think may not be that significant, may not be that adverse as for you to claim from your neighbors. Okay, so this is again pretty technical, and they have a lot of discussion on this word significant damage. So when you talk about this word significant, first and foremost, obviously, you'll find the meaning of it or definition of it or synonyms of this word significant in thesaurus, your dictionary, right? So, but when you talk about the word significant in relation to transboundary harm, in relation to environmental harm, it needs to be at a level which is absolutely serious or substantial, that you actually see, prior to the tree in your house, could it was apa ni, the trees in your house is in abundance with fruit. Let's say you have an apple tree, but because of a certain activity that seeped into your house, that tree that used to produce a lot of apples is no more, for example. Yeah. So you can see the level of seriousness or substantial change because of that harm that had led to some kind of a detrimental effect on your apple tree. So it would cover, areas of human health, industry, property, environment, or agriculture in other states. So this is where assessment of damage to see whether or not that particular change, yeah, in human health, etc., is it's so obvious, it's so significant that you would need to be given some kind of a remedy. So this is again one of those things that many researchers have tried to come up with. When it comes to transboundary air pollution, there were only two, if I'm not two, kind of assessment that was going on in terms of changes that have brought upon to human health, industry, property, transportation, the environment, and there was only a bare assessment. They didn't actually go into by measuring actual, by going into each one of those affected areas, and basically it was done more on how do you say, on that superficial scale. Yeah. um, at the end of the day, all the significant changes that we're talking about, it would depend on the facts of each case. Yeah. And it would depend on the local or regional circumstances in that particular scenario that we're talking about. So they have already set specific levels at the international level. What do you mean by significant? This one you can actually look into your own peraturan or in your own rules, yeah, your environmental acts in Indonesia, whether or not they have prepared schedule of table. For example, a certain pollutant need not go beyond a certain threshold. Yeah, so probably you can look into that. And also you look into all these guidelines for specific levels under World Health Organization and all that. Even now, when we're talking about COVID-19, yeah, we are talking about R naught. So there's already a specific level set for, not go, set for COVID-19. So if you were to see COVID-19 R naught, for example, in Malaysia, it is only 1. if I'm not mistaken, it's about 1.07. But one state in Malaysia, Selangor, has gone beyond that. So once it has gone beyond that, obviously it is considered as, could be considered as significant. Okay. One of the cases that you can look into when you talk about Chernobyl, when you talk about significant and adverse effect, you can take a look at Chernobyl accident. Obviously, this is in the 1960s, 1970s, yeah, where there was an explosion of, they were doing testing in this factory, yeah, and ultra hazardous activities were taking place, and there was this what do you call this, explosion of radioactive, yeah, and this obviously has the effects have obviously affected many of the nations surrounding Ukraine. So this was the former USSR, so now it's Ukraine. So it has affected a lot of the areas surrounding Chernobyl, yeah, and into those countries lah, yeah, more so in Hungary, Belarus, and all these countries, Russia. So they were pretty close by to Chernobyl. So obviously, not only Chernobyl as a town, as a factory, that places this particular Chernobyl, which places this particular factory, the effect thereof of the explosion had obviously transcended borders beyond Ukraine. So when you read about this Chernobyl accident, the question that arose, yeah, was, again, they were talking about the level of what significant damage has been done. So these were the questions that came about when you talk about the extent of the environment that was affected by the Chernobyl accident. First one is, to what extent have urban areas been contaminated? So they were looking into that. How, to what extent? To what extent have agricultural areas been contaminated? To what extent have forests been contaminated? To what extent have water bodies been contaminated? And how did it affect plants and animals when it comes, not just plants and animals, also to the people surrounding those areas? How did that radiation from the from the explosion of that radioactive, yeah, materials have affected plants, animals, and human beings? So if you have time, take a look into, there's so many actually sites on this, but take a look into this particular one that would tell you about the extent of the damage done by the Chernobyl accident, and how did they assess the damages done by the Chernobyl accident. Even till now, they're still assessing it. Okay, when you talk about liability issues, obviously we're talking about standard of care. I've mentioned earlier on, it is divided into three: fault, which is based upon intention or negligence; strict liability, yes, you have done it, but defenses may be available; and absolute liability means, there's no way out for you. You are liable, and that's it. So these are the cases that have supported the application of those three options. You can take a look at Smelter. You can take a look at Corfu Channel, yeah, that deals with France and another country, and Lake-Laniu case. And also when you talk about ultra hazardous activities, again, it depends on this standard of care imposed in either in national laws or in certain international agreements, such as the 1972 Space Liability Convention and also the Antarctica Convention 1988. Now, for non-ultra hazardous activities, now when you talk about ultra hazardous activities, when you talk about non-ultra hazardous activities, you need to understand what they are. What kind of activities can be considered as one of those? Okay, please read into those mentioned convention. You'll be able to see the definition on ultra hazardous activities. What would it include? Yeah. Again, when you talk about non-ultra hazardous activities, like the case that I've mentioned to you earlier, Pulp's Mill case is actually a non-ultra hazardous activities that talks about the pollution of water, yeah, caused by the mills in Uruguay. So that would be the standard of care. And obviously, after you've gone through certain things, you must be somehow or rather be given reparation. And the intention of this reparation must, well, at least, um, at least as far as possible, to wipe out all the consequences of the act. Whether that is possible or not, that's another question. It would depend on each case. And re-establish the situation which would, in all probability, whether or you can or not is another thing, have existed if that act had not been committed. That means you have to bring back that particular apple tree that I was talking about, back to the status quo, back to its original position. Now, this approach was affirmed in Shozal Factory. That was again reflected in ILC articles on state responsibility. So that is the intention of being repatriated, for this kind of damage must be given to you because of these reasons. Now, options that will be given to a state would be multifold. The first one is obviously you want to end that harmful act. Let's say, for example, the burning of forests, keeps on going day after day for the next 3 months, for the next 4 months. So you're seeking a form of reparation to stop that particular activity. That's one. Restitution is putting back into the original position, as though that thing or the activity has not taken place. Yeah. The third one is financial compensation covering costs associated with material damage to environmental resources and consequential damage, harm to people and property. So this again would depend on the list, on your list. Okay, like I've mentioned earlier, um, um, for example, during transboundary haze pollution, we all know that aircrafts cannot fly, for example, from one country to another because of the thick, air pollution that has covered the space, for example. So because of that, the aeroplanes cannot fly, and the aeroplane companies have suffered some kind of a lot of loss. Yeah. So whether or not that can be compensated, it will be one of those that you can opt for when you're asking for some kind of remedy. And the next one would be, this is an area which all of us are still muddled about. How do you assess damage when it comes to transboundary harm, especially when you talk about environmental resources? Yeah. For example, if you cannot fly a plane, for example, Air Asia cannot fly anymore to Makassar, and obviously has suffered losses, that can be calculated. But how do you calculate things like the loss of an area that has endangered flora, for example, endangered flower? How do you assess that, right? The value of it. How do you do that kind of calculation? So it is very difficult. If you were to see, in most of the, not in most, in all of the agreements, they have not placed this standard calculation. That cannot be done. And that again would cause a little bit of concern when it comes to seeking damages from states for environmental harm. Okay, some analogies. Okay, how did some of these cases work on the calculation or look at how they can assess damages caused by environmental harm? So in Trail Smelter case, which is between US and Canada, yeah, the US had actually claimed for cleared land and improvements. They were also claiming for uncleared land and improvements, livestock, yeah, property and damage to business enterprise, for violation of sovereignty, for an interest on the US on the 350,000 USD, and also damages to Columbia River caused by the disposal of waste slag. Now, if you were to see, not all, remember, Trail Smelter case tells you not all damages can be claimed for. So all this, the ones that I've added on asterisks, yeah, after, for example, livestock, they were all rejected. Okay, so the conclusion that came out from this particular case, this particular tribunal did not deal with pure environmental damage per se. Okay, because they were thinking, this also is similar to the case of the Hungary case of Gabčíkovo. they were saying that, not all kind of environmental damage can be claimed. So they took an approach which considers the market value for each and one of those items that US had claimed for. Okay, when it comes to state practices, yeah, you can take a look at the case of the nuclear tests near Marshall Islands between US and Japan, yeah, whereby US had actually paid to Japanese nationals a tune of 2 million in payment. This is a expression, basically a free one, yeah. And in this particular case, the question of environmental damage probably was not taken into account when they paid that 2 million US dollars. Also, in the case of Cosmos 954, 1978, yeah, where Soviet Union had actually paid Canada 3 million under the 1972 Space Liability Convention for the damage and expense locating, um, the debris coming from the satellite. Yeah, okay. So they had actually paid Canada for all that. Now, against UK, now the problem was this: against UK had a big problem, yeah, when it comes to this affirming whether or not state liability can be imposed on those countries which have done environmental harm to another country. Now, UK had a big problem then. UK was also involved in this problem of acid rain in Scandinavia countries, and also had caused some kind of contamination of the Irish Sea by nuclear waste from Windscale and Sellafield nuclear plant. And again, UK was in this turmoil to have alleged damage to Australian territory from nuclear tests in 1950s. So basically, UK, yeah, UK, US, Japan, Soviet Union, yeah, to say the least, they are actually reserving their positions on this state liability issue. Yeah, because if they were to do that, you can imagine the immense amount of money that needs to be paid to the other countries that have been affected by their activities, okay, by their decisions. So you can just imagine if they were to agree, right? Now, when it comes to this concern about nuclear accidents, yeah, and this highlighted this again, the same problem in the Chernobyl accident, yeah, and UK again was reserving their position to take any action against USSR, because remember, if you were to see that map, somehow or rather the pollution that went across Chernobyl and into the other European countries have shown this, this strong indication that USSR needs to provide reparation. But again, UK was not agreeable to this because UK had the same problems with all the Scandinavian countries, the Irish Sea, and also the Australian territory. So they were not a little bit reluctant in terms of affirming this question on state liability. So when you talk about nuclear accidents or nuclear damage, you look into this role of IAEA. Okay, and IAEA is the organization, international organization, that governs issues on nuclear installations and anything to do with nuclear. And in 1989, they came up with this Standing Committee on Nuclear Liability, which they were amending. They were amending some kind of guidelines or rules on nuclear liability, which obviously France, UK, and US opposed. Yeah, they didn't like the fact that this issue on state liability came up. Okay, because they are doing a lot of trouble for the other countries. Obviously, they're trying to kind of cut it off. Right, so that would be the political part of it. Now, the other one that you can look into would be UN Compensation Commission. Compensation Commission was established in 1991 because of the Iraq's unlawful invasion of Kuwait. If you can recall, in 1991, if you had read some historical background on what Iraq was then and what it is now, with the intervention from the United States. You'll see there is some claims for environmental damage and depletion of natural resources during that war, that ongoing war in 1991. Yeah, it went on, I think, for 1 year. And after which, the US had intervened, United Nations intervened, and they were trying to stabilize the political structure of that country, even up until now. So there were some kind of claims caused by the invasion, so-called invasion by Iraq. Yeah? And this would include losses, expenses, from abatement and prevention of environmental damage, because obviously during war, even now what's happening in Palestine, and Israel, a lot of environmental damage will be, is done. And how do you need to restore the environment? Yeah. So all these losses, expenses that you need to write down in order to make claims are utterly important. Yeah. So this one, in terms of the reparation for the consequences of Iraq's unlawful invasion of Kuwait, you can somehow make an analogy or make a comparison to what's happening in Palestine. Yeah. And whether or not Palestine can come up against Israel for those claims for environmental damage and depletion of natural resources. So this would be something that, I don't know, United Nations is not intervening at the moment. Yeah. Whether or not this can be realized is another thing. Okay, so that would be the state practice. Then we move on to the treaties to see this appearance of rules on state liability. Yeah, you can find them in 1972 Space Liability Convention. Remember the one that I've mentioned to you earlier, where the Russians have paid Canada a certain amount of money because of the disperse of aircraft or satellite in space, and that has caused some kind of rippling effect on Canada. So the question, when you talk about this particular Cosmos 954, the question that was raised, again, on the definition of damage, which can also be inclusive of environmental harm done to Canada. What kind of environmental assets or natural resources that can be referred as something which, environmental harm can be caused upon due to the space object falling off the space and, damaging certain things in a particular state. So take a look at this case of Cosmos 954. So you can say that it appears in Space Convention. You could also see that this state liability also is also embedded in Long Range Transboundary Air Pollution Convention. This is between US and Canada, yeah, under Article 8, that allows for some kind of a state liability to be imposed. And you'll be able to find that also in the United Nations Convention on Law of the Sea. So you'll be able to see in one of these articles, Article 235, Article 139. And also, if you were to look at what's happening right now, we always talk about climate change and all that. Actually, there's no expression of liability, but there is an expression of financial funding or financial help among states, yeah, in order to reduce this climate change conditions in the global level. So basically, when you talk about state liability, again, I stress on this notion that not all countries agree to it. Yeah, they have their own standards and they have their own interests. So in other words, when you talk about liability, we can discuss it further. But to what extent can a liability be imposed? That is another question, and that has not been resolved till now. Okay, so that would be on state liability. Well, what about civil liability? You as a person who has been damaged, or who has suffered losses, who has probably have persons who have, have lost lives because of that particular activities taken in another state, have caused harm in your country. What can be considered as liability that can be imposed to the other state for injuries that have, or loss, or suffering, or harm that have been done to a third party like the public. Okay, so you can take a look at the 1960 Paris Convention, which actually states, yeah, there is such a thing as third party liability and insurance against nuclear risk. So when you talk about Paris Convention, you're talking about nuclear activities. So you can take a look at Article 1, where it says the liability. So this is pretty clear, yeah, in 1960 Paris Convention. So it allows for us, yeah, to take an action against a private entity or a state that carries out that nuclear installation, yeah, that governs or that carry out the operations of that nuclear installation. So it could be a state operator, or it could be a private entity, a company, private companies as the operator of the nuclear installation. The other one is when you wish to take an action against such operators, you need to prove again, yeah, you need to see the causal connection between the damage and the nuclear incident. How do you connect the two? Next, it also states in the Paris Convention that the claims must be brought within 10 years from the date of nuclear accident. So anything is something like civil, what do you call this, limitation clause, yeah. Yeah, in Malaysia, it's 7 years. You want to take an action against somebody else under civil claims. And obviously, those judgments that come out from such um, cases, it must be enforced, yeah, in the territory of any party. So this is quite clear, because if you were to take an action in France, for example, and it's against Spain, so both countries can actually enforce those judgments in either one of those countries. Okay. Next would be the increase of total amount of compensation that was brought upon by the 1963 Brussels Convention. So it has increased from one amount to millions of amount. I think you can look into that yourself. And also 2004 revision of Paris Convention. I'd like you to see or look at what kind of revision, what kind of changes that brought upon by the Paris Convention in 2004. Okay, and this question on applied to contracting state only. I want you to read on this, and that there are various materials on the revision of Paris Convention, yeah, and what changes has been made to this Paris Convention relating to nuclear risks or nuclear activities. Okay, so when we have that Paris Convention, then came about this Vienna Convention, also talks about nuclear activities. So what they did was this: they had a joint protocol between Paris and Vienna Convention, whereby it says the operator of a nuclear installation in the territory of a party, let's say France, yeah, France has ratified Paris Convention, whereas Russia has ratified Vienna Convention. So if one of those countries have been found liable for nuclear damage, yeah, you know, uh, both Paris and Vienna Convention can be enforced. It doesn't matter, okay? Because if you were to see one country and the other country, they've ratified two different conventions, but it doesn't matter. If, let's say, France has imposed or stick to Paris Convention in order to make this Russian counterpart liable, of which the Russian counterpart is not a member of Paris Convention, it does not matter. Russian will be liable under Paris Convention and vice versa. Okay, so that is the significance of the joint protocol in 1988 between Paris and Vienna Convention. Now, that is for nuclear risks. What about in terms of civil liability for damage caused by oil pollution? Yeah. Now, when it comes to oil pollution, happens in, the big one was in Exxon Mobil, but that was in between America and Mexico. yeah, and also in the Bay of like a Biscay Bay, yeah, of um, in America, and there's so many incidences of oil pollution, yeah, and the damage caused to the environment. But basically, generally, when it comes to civil liability for damage caused by oil pollution, it's governed by three international instruments under the International Maritime Organization. So the three would be the 1992 Brussels International Convention on Civil Liability. That means other persons, can take an action. Third persons can take an action against the ship owners, for example, or the state, yeah, that where the ship was registered in, right? For example, Brussels International Convention on the Establishment of an International Fund, that's known as the Oil Fund Convention 1992, and also the 2003 Supplementary Fund Convention. So basically, what it does is it provides for some kind of provision whereby you as an individual can take an action against the ship owners, for example. Okay, for any environmental harm. So take a look also at IOPC fund practice, which allows compensation to be paid for loss or damage caused outside the ship by contamination resulting from the escape or discharge of oil from the ship. So this is one of the illustration that I can give you, the Antonio Gramsci, a Soviet registered ship in 1979. So kindly take a look at that as well when you have the time. And obviously the other claims that have been brought under the IOPC for environmental damage is the Patmos Claim, the Haven Case, and the Erica Claim. Now you'll be able to find this all in ICJ, and it makes an interesting research if you're into this, looking at the measure of assessment, yeah, when it comes to environmental damage for these various cases under, for example, the Patmos Claim between Italy versus Greek. And again, in Patmos Claim, the jurisdiction or the forum where the case took place was actually in Italy, okay, for example, in 1985. And another area of concern when you talk about civil liability, it's when waste is concerned, yeah. So you can look into this 1989 Basel Convention, where it highlights the liability for civil claims if any damage was done to persons and properties and loss of income deriving from economic interest in the environment caused by waste, movements of hazardous waste and their disposal. Also, you can claim for cost of preventive measures, and it can apply to damage due to an incident occurring during a transboundary movement. Now, in this particular liability application, you need to look into the strict liability approach, yeah, where defenses are provided for the violators. Okay, there's also some exclusion to this particular 1989 Basel Convention. That particular violator can actually be excused if it is found that certain damages, or loss of income and so forth, that the persons are claiming from were caused by armed conflicts and insurrection, natural phenomena, and the wrongful conduct of a third party. And the jurisdiction which is appropriate for such claims to be brought for movements of hazardous waste and their disposal would be where the damage was suffered, or where the incident occurred, or where the defendant has his habitual residence or principal place of business. In other words, what they're trying to say is that the courts of jurisdiction would be, in the country where the damage has occurred, right? Or the incident has occurred, yeah? Or if, let's say, the defendant is elsewhere, in Japan, for example, so we can take, the case to Japan for that person to be tried under 1989 Basel Convention. That's for waste. Now, other international instruments when it comes to civil liability, you can find them in transport, yeah, transport activities that may cause environmental harm. Obviously, when we have all this 1989 Geneva Convention on Civil Liability for Damage, etc., CRTD, and also the NHS Protocol. Funnily enough, unfortunately, that both are not enforced. So you can see that, the international community is not really supportive of this. You know, they have their own reasons, yeah. And also Antarctic, the 1988 CRAMRA, where it states specifically in the provisions in the Antarctic Convention, um, where it addresses liability issues. Again, this is not enforced. Yeah. You can read this on your own if you're interested in looking at the international instruments that govern civil liability. That would be on transportation and also on what do you call this? On Antarctic. The other two would be if you're interested in biodiversity, yeah, and also into the damage resulting from activities dangerous to the environment, which is under 1993 Lugano Convention. So if you were to look at Lugano Convention, again, it is not enforced. Yeah, it is only kind of um, I think they were just testing, right, to see how favorable this civil liability provision that will be inserted into conventions will be looked at, you know, by various members of the international community. Now, for biodiversity, you know, at the end of it all, again, you know, it would rely on the domestic law of those countries that have ratified biodiversity protocol. So you see, you know, people, you know, you get a feel of that. The international community is not encouraged by state liability nor civil liability, you know, placed in set standards, you know, set standards in international instruments. They're not agreeable to this. They're not accepting of this. Okay. The next one would be when you talk about civil liability protocol, you can look into the 2003, where it talks about transboundary water resources. And within that, it gives some kind of provision that will allow individuals or other persons to take action against those countries or operators that causes some kind of a transboundary effects of industrial accidents on transboundary waters. And these other people or third party would include fishermen and downstream waterworks. Okay, so that would be kind of the end of my presentation, but I wish for you all to wonder and discuss amongst yourselves, yeah, after listening to what I have highlighted. And obviously, like I've mentioned earlier, this is not exhaustive. You can do your own research because there are many out there, many of the materials out there, international agreements, treaties, and even domestic laws that have this civil liability provisions within their laws, and also see where do countries right now, yeah, as at present, agree with this notion of um, international treaties or agreements that embed this rule of international law on liability. Okay, so at the end of it all, you'll be able to see even some of the jurists, some of the writers on international environmental law agrees that, you know, we talk about international law on liability, it remains underdeveloped. We're still deliberating about it. We're still trying to agree that the state liability should be imposed in a holistic manner. So it rests again on this notion of cooperation among states, and I think you will find that in ASEAN, yeah, especially ASEAN. Yeah, when you talk about transboundary haze pollution or transboundary water pollution, when you talk about piracy and all that, yeah, we rest on cooperation, yeah. And this opposes the Principle 13 of Rio Declaration, which finds that there must be some kind of laws on liability and compensation, the importance of it. Or else nobody is going to take any responsibility, isn't it? If you were to do something wrong, you must be penalized, you must be punished. But, you know, if you don't kind of affirm this and place this in an international setting, then, you know, people get away with things. Um, the other thing that I want you to look into would be the issues of concern which relates to the assessment of liability. Now, this is when problem begins, when you're trying to calculate damage, yeah, especially when it is beyond your national jurisdiction, right? Question of financial limits: how much is enough? How much is sufficient? In order to pay for that particular environmental harm, right? What is sufficient? It depends, yeah. And this question on causation again, which I mentioned to you during my presentation, is causation. How do you relate? How do you connect the chain of proof, yeah, from the cause right up to the effect of that particular activity? An attribution of liability meaning how much uh, how much responsibility is attributed to the state, how much what is the portion that's given to the contractor. So let's go back to your to the example, or the case that I've given to you earlier about your neighbor and yourself. Your neighbor is the owner of the house. The contractor is building the building swimming pool that has caused the harm in your home. How do you attribute or apportion responsibility amongst these two? That's another question. Yeah. Now, effective procedures before courts and tribunals. Again, when you talk about placing liability on persons or on a state or individual operators or individual contractors and so forth, the courts must already have a set procedure, meaning from investigating procedures right up to enforcement of judgments. Right now in Malaysia, when you talk about, we are actually revamping our own environmental law act, yeah, to make it even more effective by placing some kind of new procedures, forensic, for example, forensic assessment or investigation into how do you calculate, how do you look into this problem of causation, from the cause right down to the effect of that particular activity. So all this would again be interdependent to one issue and to another. So that's something that we need to look into. Next is, finally, at the end of it all, when you talk about liability for environmental damages, the development so far suggested that it's kind of slow, but it's somehow proceeding towards something which hopefully all countries would accept. Yeah, that there must be some kind of liability imposed on states for whatever activities they have been conducting, that have posed some kind of serious damage or harm done to another state. So um, in that manner, I think all of us have a lot to play, especially as yourselves. You're going to be young lawyers, probably. You might be interested in this area of law. You might like to look into this question of state liability. Ask yourself, in Indonesia, or Indonesia as a state, has it done anything to any other countries, not within ASEAN, other countries, for example, on the activities that Indonesia has taken so far that have caused damage to the environment? So in this case, you've got to be objective. You cannot be emotional. You've got to be objective, because at the end of the day, it rests on our values and our conscience, and this will be interpreted into the laws on liability for any kind of harm, be it environmental harm, be it not, be be it an environmental harm, or be it a non-environmental harm. Okay, so I suggest that after this, you look back into that list of yours and figure out again, what would be the best method. Yeah, what would be the items that you would consider making the other person to be liable? Answer those questions that I've given to you earlier, the factors in which you um, need to look into when you're looking at making another state liable, okay, for the environmental harm. So look at your situation just now, your neighbor and yourself. Right. So, Bu Rafika, I think that's where I should stop right now. Yeah. I hope that all of you, I know it's like nearly 2 hours. Yeah. I'm sorry about that because there's an issue which is very close to my heart. I'm still looking for answers to certain questions which other states have done to us. And in particular, this is not to rile up your sentiments about transboundary haze pollution, yeah, but when you look at the problems that we have had, this could be an area which we should look into. It may not happen to us. We may not be the cause of it. Some other country may be the cause of it. Then perhaps you might just like to look into this question on state liability or civil liability. Right. So thank you very much, Bu Rafika and the rest of you. Hi, Nisa. How are you? Saya kenal dia, Bu Rafika. Dia
Yeah.
macam she was my, how do you say? She was my host when I was there in Makassar in 2019, I think. Nisa and siapa seorang? Ines.
Ades, Professor. Kak
Ah,
Ades.
Kak Adis, yes. So thank you very much. So if there are any questions, I see there are questions here. I shall
Yeah.
answer them if I can answer them. Yeah. Okay. Class, you have any questions? You have a technical? Okay,
This
fine.
one.
Right.
Fitriani
Question.
Shabina.
Okay, there's one message here from Andi Firiani Shabina.
Oh, you got the question already, Professor.
Right. Okay. I will just read the question. I would ask questions related to state liability, which states that apart from the state was asked for compensation, another factor is asking for yes. And so how often this supposed that diligence should be conducted? Does it depend on state regulation or perhaps the condition of environment? Very good question on due diligence. Now, when you talk about due diligence, this is again another moot question that we're looking at. Due diligence means basically anything that you can do in your power, whatever measures that you can do in your power to prevent any environmental harm. For example, let's go back into that situation where the neighbor and you again. Okay, the contractor is building that swimming pool. Now, he's an expert in it. He's got people, if he's not an expert in it, he's got people who are experts in it in building that swimming pool. Next question would be, he knows that certain things, looking at the condition of building swimming pool at the neighbor's house, it would cause some kind of environmental effects, some kind. Because when you're digging, remember when you're digging your soil, right, it will cause some kind of instability in the soil structure. It will cause some kind of degradation to the soil. It will cause some kind of pollution in water. It will cause some kind of probably a certain structure. The water pipes will be affected, and basically the ecological state of the neighbor's house will be somehow changed. He knows that. The question is, and he's gone through so many building of swimming pools that he knows that something will happen. Question is, when you talk about due diligence, has he gone through every single possibility that may occur and do something about it? Meaning, has he assessed the situation? Has he come up with some kind of precautionary measure just before it happens? Or he said, it is bound to happen, but how do I prevent it from being, from getting worse? So if he has not done anything of the three in order to prevent that environmental harm from happening, from that water gushing out into your home, then he would have failed in his responsibilities to carry out due diligence processes. Now, I want you to look. Siapa tadi ni? This is a very good research area on due diligence processes, especially for companies. If you were to look into companies, corporations, multinational corporations, if you were to look into your own national corporations, yeah, the domestic corporations, and if you have company laws or guidelines for companies, you'll be able to find this word due diligence within the ambit of your of the act, of the regulation or the legislation. Now, if you like, siapa tadi Andi Firiani, okay? If you like, this due diligence question does not actually, at least in Malaysia, yeah, it does not appear anywhere, you know. This is more or less like a term which is used by jurists in order to encapsulate the responsibilities and obligations of companies, of states, international persons before they conduct something, you know, conduct their own activity. It does not appear anywhere, this due diligence. If you were to see environmental treaties, I want you to look into ours, yeah? The ASEAN Agreement 2002, Transboundary Haze Pollution. Take a look at that agreement and check, ada ke tidak ada perkataan due diligence. Cuba check. Because due diligence, if you do not carry out this particular assessment, you will be responsible and you'll be considered as breaching duty of care. Because you, in the first place, if you had known, if you're a professional, and let's say for doctors, lawyers, have you come up with due diligence process? As companies, have you come up with questions to prevent something from happening? So sometimes it doesn't appear anywhere. It is only a term. But in companies right now, at least this due diligence process, try to check the draft or international law, if I'm not mistaken, on human and business rights, responsibilities on business and human rights. Take a look at that particular draft and see whether or not this word due diligence appears and what does it entail. I'm sure in your regulation, this word due diligence does not appear, at least in your environmental act. Yes, Rafika, Bu Rafika.
I think in Indonesia, we have this what they call environmental assessment. I don't know whether that's equal to due diligence, but before they establish something, there have to be like environmental assessment.
Exactly right.
But in fact,
Exactly right. That would be one of the method that you would need to carry out in order to your due diligence. Yeah. EIA, yes, it does not say due diligence as such. They normally, come up with what kind of method that you need to come up with in order to prevent. So EIA is a fantastic example of that. If let's say, let's say for example, the contractor or the owner, your neighbors, have come up with an EIA, for example, a small EIA assessment to see whether or not, ecological state will change because of that building of the swimming pool. And if they have done so and they found out that, there'll be no kind of changes to the soil and et cetera, and therefore this problem of water seeping into your home does not even arise, then that due diligence would have stuck with them. They have carried out that conduct. So EIA is one of the fantastic example when it comes to conducting due diligence process. Okay, next one will be, let me see. Morning, Prof. Hanim. I have an unstable network. I've read about Notion. How do you think to bring, let me see, to bring an individual for this kind of responsibility for as one of the various crimes and crimes? How do you think about that issue? Will it bring? Okay. Now, normally we talk about civil issues. When you talk about environmental criminal, yeah, acts. Yeah, when you talk about environmental criminal acts, normally you talk about illicit activities. Criminal, yeah. One is liability to provide reparation. The other one is to punish them. Punish means it relates to criminal acts. When you talk about criminal acts under environmental law, probably the closest thing that I can think of is illicit trafficking of wildlife species, for example. Okay, and there is an international treaty to stop all this illicit trafficking, illegal trafficking of wildlife. In Malaysia, we have an act on this. Yeah, and there have been cases, cases on people bringing in even our own nationals, trafficking all these wildlife goods into the country and exporting them to other countries. And we have tried them under our own jurisdiction, and they are found to have breached not only the domestic law, but also the international law. Yes, it is possible. So it depends on the type of criminal act that we're talking about. Okay, or we're talking about one of the other one would be illegal movement of living organisms, living modified organisms, for example. That could be considered as a criminal act. Theft. Okay, there are few, but yeah, I mean, when you talk about environmental criminal acts, yes, we can take an action against those individuals. Right. Any other questions? I hope that all of you get some idea on, liability that we can claim against the state, and also you as a person who's suffering from some kind of environmental harm caused by another state or another international persons. I hope you can see the overall picture on this. Yeah. Okay, Bu Rafika,
Yes,
uh, ada apa-apa lagi ke? Ada apa soalan?
um, I don't know, but I would like to discuss about this. I've been working on the issues of climate-induced displacement of persons.
Hmm.
Yeah, the climate refugees things, and then these the head of states in from the Pacific Island states
Hmm.
would like to ask the responsibility from the developed
Hmm.
countries, but because they are the one who should be responsible for the this rising sea levels that will cause them to their country to submerge in the future. So, but even like in at the international level forum,
Hmm.
even when they in the sustainable development goals, they already create forum for the indigenous people, but
Hmm.
I've seen none of these members are actually come from the Pacific Island or the affected countries.
Hmm.
And when I followed I followed the news, why someone asked why you never include them, no, or you don't include them as one of your decision maker. And this head of this the member of the forums say that because none of them is capable to answer or have a capability to answer this kind of issues. Professor, what do
Hmm.
you think?
Okay, to be honest, I've met one of the spokesperson during this United Nations Environmental Program and ADB conference, which was held in Myanmar. I can't remember the name of the fellow, but he was a very good looking fellow. He was talking on behalf of his island. Now, I can't remember the name of the island as well. I can only remember the video. But I was very moved when he showed the video, Bu Rafika, about what they had to go through when there is this submerging of, when their islands submerge due to the increase of water, sea water level. Every time when there is flooding, you'll be able to see them putting on sandbags, sandbags surrounding certain areas, and also they were planting trees, and supposedly these trees is one kind of a method that could prevent the water from coming into their land. Now they have raised this issue. It was a very sensitive question that was raised by this fellow, and they actually forwarded this to some of the developed countries, the first world countries, and he was asking. He said, in 10 to 20 years, they can foresee that the rise in the seawater level will somehow flood the island, and they will have to move away, definitely, even prior to that. The question is, you talk about displacement of communities, yeah? The problem is now, some have ran away. Some have ran away, but some still stayed behind because, they're very close to their country, right? So this sentiment somehow bonds them with their country. But at the end of the day, they were saying, if there is a situation by which we need to flee the country because of this,
Yeah.
which country would accept us? So
Yeah.
this is a question of immigration,
That's
right? Immigration. And obviously the immigration rules would apply. If you were to go to the United States or Australia, that is the closest country, which is to the island, they would have to abide by the immigration rules. Now, the question is whether or not they make some kind of exception to those population that's been affected by environmental harm.
That's right.
So I'm not really aware of the situation right now, but as far as I know, uh, the response which came back was rather discouraging to a certain extent. They may look, all these countries say, oh yes, we will help you, we'll do all this for you, blah 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 blah, but at the end of it all, it is all lip service. It is so that that's an important question. Because of environmental harm caused by climatic change conditions, these things happen, and it will occur. It will continually occur. Maldives is also facing a problem. Venice is also facing a problem. Jakarta is also facing a problem because it is going to submerge with, in I don't know, in when, Bu Rafika?
What is that?
Projectionnya Jakarta akan sink
Not sure in a few years.
in a few years. That's right. And that's why
20 in the 10, 20 years.
Yeah, but you cannot wait till then. You've got to remove them, right, from that section. But the problem is you have land in Indonesia. The problem with all the small islands, small Pacific islands, that's it. That's a few square meters, and that's all that they have. But the question is correct. I don't have the answer to that question, but what I feel is that the international law and the international community must make way for these people by coming up with, I don't know, kind of an exception, to the rule. They can't buy lands, of course. They can't buy countries. They are poor. They are poor. They're not like, earning billions and billions of dollars in revenue, national revenue. They are not. They are poor people. I mean, we have to say that. They don't have money, right? In order for them to buy a country or buy a piece of land, and but the international community must understand this and must make an exception for these people. And I think that's more to good conscience than anything else. Bu Rafika, you want to make it into law and all that, all sorts of political interests will come in, economic. Oh, I tell you, it's a mess, But I think when people stick to the rule of good conscience, humanity, that would be something that most of us forget. I don't have when it comes to the law and policy, it depends on the interests of that country that's willing to admit people from the Pacific. Yeah.
That's really interesting, Professor. I've been working on that. since my master degree.
Yeah.
I took the research on that. But
What have you found? What have you found so far?
yeah, the experts keep arguing whether they have to keep the existing refugee law or they have to make some a new kind of international agreement that can cooperate the
Mm,
needs of
mm,
that kind of issues, because
mm.
it's very complicated. It's not just about how they can move, but about
Yeah,
we have to consider their cultures and
exactly.
their dignities and many things. Yeah.
Yeah. And somehow countries make it difficult
Yeah, yeah,
by coming up with all these treaties and number
yeah, yeah,
one, this must be this, this must I tell you,
yeah.
it's so difficult. They make it more complicated. In other words, at the end of the day, they are reluctant, or else they
Yeah,
wouldn't come up with with continuous discussion on this,
yeah,
and they are like going back and forth on this, whereas at the same time those people are suffering.
yes, yes,
Yeah,
yeah.
interesting. Carry on with the research, Bu Rafika. Carry
Okay.
on with that research. Yeah.
Yeah, thank you very much, Professor.
Okay, thank
I
you.
think you still have a class tomorrow.
Next week I have a
Oh, really?
class.
Tomorrow?
Next week on Monday.
All right then.
On
I
Monday.
think. Oh, are you
Uh,
available for one more question?
yes, sure. Nisa,
This
is
one.
it Nisa?
Please.
Yes, Nisa.
Thank you, Kak Rafika and Prof. Hanim. So I think it's a basic question, but I will ask it anyway. So, Prof. Hanim, if there is a private company causing environmental damages,
Mhm.
then under what jurisdiction will it fall? Who has the right to decide under what jurisdiction the dispute can be settled? Because if the private company and in the same territorial, then it will be under national regulation. But what if it's on the other country? Thank you.
Right. This is a very tricky question. Because when I was asked to draft the Act on Transboundary Haze Pollution for Malaysia last year, this is actually one of the areas that I had to look into, because I understand that business operators may not necessarily come from Malaysia, but also those companies that are subsidiary that put up or operating in Indonesia, for example, but the parent company is in Malaysia. Now, in it's very simple actually. When it comes to those countries that are affecting the environmental conditions in that particular country, then obviously the jurisdiction will be under, for example, Malaysian law, right? But when those countries, let's say, the same company has a subsidiary in Indonesia, for example, and that subsidiary company is registered in Indonesia, then the jurisdiction or the right forum would be under Indonesian law. Okay, but um, I'm just giving you a glimpse of what I did for the government of Malaysia in trying to come up with a draft of laws for liability under transboundary haze pollution. The team of experts and we have decided that, at the end of it all, we're looking at all the possibilities. Obviously, we would like to take an action against our own company in Indonesia that has committed that violation. Obviously, we can't, because it has to come under jurisdiction of Indonesia, right? So what we can do is to link the relationship between that subsidiary and the parent company in Malaysia and place that liability or responsibility under the parent company for the activities taken by the subsidiary company in Indonesia. So in other words, the one who will be tried in court will not be the subsidiary company in Indonesia. It will be the one in Malaysia, the parent company. So we're linking obligations and responsibilities under company's law, the law of company. Okay, so at the end of it all, again, jurisdiction sticks, Nisa. If it's in your country, then only the laws of those countries would take an action against. But if it's in in that particular situation, then you can link the two. But that is difficult to do as well, because remember, it links back to the burden of proof. And obviously those companies, the parent company, and say, hey, look, I had know nothing of this, I have no knowledge of this. And they will come up with all sorts of defenses saying, hey, look, I'm not at fault here. I'm not the right person for you to make a claim against. Okay, but it's worth a try. It's worth a try. Yeah, because at the end of it all, when you talk about laws and policies, when you talk about practicing laws, you need to be creative within reason, lah, right? You need to be creative, and you need to somehow evolve using all kinds of the laws that we have right now. How do you evolve? How do you make the law work? So you've got to think of different ways and methods by looking for, in that particular situation, you're linking international law and domestic law at the same time. Okay, I hope that answered your question, Nisa.
Thank you so much, Professor.
Okay, thank you. Thank you. All right. Okay, Bu Rafika.
Thank you very much, Professor.
Tidak ada masalah. Terima kasih banyak-banyak kerana menjemput saya. Thank you so much. Thank you so much. Thank you so much. I hope all,
yeah, I hope we can see, not online.
Yes, yeah.
Future, yeah.
Yeah.
And
so next,
sorry, what's that?
You were breaking up just now, Bu Rafika.
Oh yeah. So I think we will see you again, inshallah, next week. At this time.
Can we take a photo? Can we take a photo?
Oh, sure.
Yeah, can we take a photo? Can everyone open their video so that we can see your... Yeah, can you take a photo?
1 minute, please.
Yes.
I think some students already left, or they have...
It's fine, it's fine, it's fine. I just need this to put this in my... to show to Pak Maskun juga, ya?
Oh, yeah, that's right. I always forgot about this.
Okay, can everybody open their video, please?
Everyone?
I'm sending this to your Pak Maskun, ya, to your lecturer.
Yes.
Ada lagi?
The next page.
Okay, wait, hang on, ya. I just...
This one.
Okay. Next page. Let me see next page. Oh, next page. Belum buka lagi ya. Next page.
Is showing up.